does seem simple, especially when you have a system like MERS where all they have to do is log onto the computer system and indicate there, type in that the new owner is the new bank. But apparently this wasn't going on. There was such a frenzy of this trading and, actually moving physical notes, which is really the only legal way that they get transferred, is actual physical delivery of the notes. Inputting it into MERS is just their system of who they think owns it now based on what the banks themselves are putting in there. But the physical delivery of the notes that is the change in ownership under the Uniform Commercial Code, under the New York Trust Law, because all of these trusts were set up under New York law. They have to be delivered to the trust, to the trustee to hold for the trust. And apparently that wasn't happening. We've asked for some very simple documentation that is required by every one of these trusts. They have what they call the pooling and servicing agreement. That's what they call it PSA for short. That's required for every trust. It sets up the trust and it sets up those obligations for physical delivery of these instruments. Anyone can see them. They're all filed. They're all publicly filed with the SEC, and you can read them. And they specifically say, I can tell you, it's Article 2.02 in every single PSA is the conveyance article, and it tells what has to be delivered there, and it's the original note, the original mortgage, the assignment, and it also requires some certifications from the trustee. Now that they're the ones receiving these documents, and they have to certify in a single-page document, I have received all of these original instruments, and then they certify again a little bit later. This is the time when the trust is being created. Right after it's created, they certify again. They have looked at all the records, all these instruments. They received what they're supposed to receive. They all comply with the requirements. And so there's these 2 pages, very simple documentation that's required in almost every PSA I've ever read. We ask for them in every single one of our cases, and you would think it would be very easy to provide these 2 certifications. And I have yet to have a bank be able to provide that.
Once again, a reminder, my guest is Tom Ice. He's a lawyer in Florida, and according to an article in Reuters, he's playing a principal part in legal challenges against foreclosure practices by mortgage lenders. And he says that this U.S. housing morass is only going to get worse. And as he's talked, we've found out that sounds highly plausible. Well, let's talk about foreclosures aside. Typically somebody right now, the process they go through first before foreclosure might be trying to refinance, might be trying to get some kind of a modification or some help in some way. This whole mess makes that even very difficult, doesn't it? So there's really no way for a person to get this done correctly.
Well, from my client's perspective, that's the real problem here. We as lawyers talk about, well, the note didn't really get transferred there, so they're not really the owner. It's some other bank down in the chain. My clients don't care about that. They care about every single one of them paying their debts, getting some sort of loan modification that allows them to get on with their lives, keep their house. If you can't get the owner to the table, the person who really owns that note, a decision maker who can modify the terms of that, they can't get what they need. And that's why all of these federal programs have been such a disaster, like HAMP, and they're not getting very many people loan modifications, is because the real owner hasn't shown up. Will the real owner please stand up and come to the table and negotiate these loans? I mean, all my clients, they got into a situation because the economy collapsed, which, can be traced back to the whole securitization problem anyway. They lost their job for a couple months, or maybe had their wages cut back, but they all, want to keep their homes. Some of them come in, or, they're crying at the table that they've lived there for, 15 years, and they want to keep their home. But they can't get anyone to talk to them about a loan modification, and neither can I. I mean, I asked the court for mediation, to require mediation, So we can go down and talk to the owner. The mediation requires that a person with authority to settle the case without consultation of anyone else, in other words, they can come and modify the terms of the loan. They're required by the rules to do that, but invariably the servicer shows up who has absolutely no authority to do that. So nothing happens. And that's the real shame here, is that so many people just want to do the right thing. They can't because of the economy, and no one's stepping up to help them fix the problem, even though, sadly, the U.S. taxpayers own most of these loans anyway because they bought Fannie Mae and Freddie Mac and own 2/3 of Ally.
Right. Now, you're in Florida, which probably there are no shortage of people coming to your door in that state, like there is here in Arizona and our neighboring states, California and Nevada. Do you think a simple solution that's been proposed, but it was voted down by the Senate, would be to allow bankruptcy judges to actually force a modification of a loan, which would, I guess, go around the problem that we're having of documentation?
Absolutely. That's something that I see as an easy fix, or at least something that a lot of my clients would jump at. And you can do that already. It's called a cram down, where you can have the court fix your loan, modify it down to the value of your home. And so many people are underwater. That's the real fix that we need. A lot of people are walking away because they're so far underwater, they're thinking, I'm going to have to pay for 10 years just to get back to zero. You can do that with investment properties, but you can't do that with your primary residence right now in bankruptcy. And, of course, that was a change brought on by the banks. When the bankruptcy court laws were first instituted, you could do it with all your properties, but they had that changed. And like you say, last year they tried to change it back, but it was voted down after a lot of lobbying by the banks. But what I'd like for the banks to understand is it really would fix this problem for them as well, because they're facing a lot of title issues now.
And I guess finally, in closing here, what are you telling your clients? Because it looks like here in the situation where you've got a lot of clients who may be indefinitely delaying what could possibly happen in foreclosure. Do you see a light at the end of the tunnel for you and your clients? Because it seems like there's sort of an impasse here, that you really can't get what you need, and the banks won't give it to you because they don't feel like stepping forward because they don't want to admit they have all these bad loans.
Yeah, we are at an impasse, and it's sad that the delay that's being caused by this actually harms my clients as well. A lot of people out there saying, it gives us if there was a moratorium, they'd have another 3 months in their house or something like that without paying a mortgage. Like I said, my clients want to fix the problem, and every month that goes by, it just accumulates more interest, more attorney's fees on the other side. It becomes a bigger and bigger nut that they just can't pay off. And a lot of people can't take the stress of the litigation, just the waiting for the other shoe to drop. I've lost many clients who have just decided I can't keep going like this. I'm going to walk away, even though they had terrific cases, not just because they had robo-signers, but because at the beginning they were duped into interest rates that they didn't realize that they were signing off on. So it really disturbs me when I see that happening. So the delay is not good for us. I really would encourage lawmakers to step up, do something like the bankruptcy, or do something that will resolve the problem more quickly.
My guest is Tom Ice. He is with Ice Legal in Royal Palm Beach, Florida. You can read the article we're discussing along with the post on this podcast, and you can check him out at his website. What is your website there, Tom?
IceLegal.com.
I knew that. I was just testing you. Tom, I appreciate your time. Thanks again.
Oh, thank you for inviting me. Thank you.